Hi, everyone. So, I am going to lecture about human rights and specifically how do we analyze policies and motions with human rights from a human rights perspective. So, a little bit about me is I took a course in human rights theory and practice in law school, and there we drafted petitions for like writs of kalikasan, writs of habeas corpus, etc. Those writs are legal remedies that we have under our present legal system with which people can safeguard their rights. So a writ of kalikasan would be against like a government or an institution that is violating an environmental law and it causes damage to inhabitants of two or more cities. A writ of amparo is there to demand freedom or some redress if there are enforced disappearances or extrajudicial killings. Habeas corpus is if someone is deprived of their liberty. But more than that, we also drafted individual communications and complaints to international human rights bodies like the UN Human Rights Council. And that's just from the perspective of how does human rights lawyering work. I am not going to teach you how to draft those petitions because that's not very useful to you. Rather, we were also taught about what is a framework by which we can understand and talk about human rights. And this would be very useful, not just for you as debaters, although I really am going to talk about how it will be useful for debaters, but I'm also going to talk about how this would be useful as an advocate. For example, you're part of an NGO, or for example, you're just an individual. How do you construct like arguments from a human rights perspective and send it to members of Congress or your local representative or legislative, stuff like that? Because most of them have a legal department, they have legislative assistants as well. So even if they might not be able to read it themselves, probably one of their staff can read it and make recommendations accordingly. So I'm going to talk about like how do you structure that from a human rights perspective. So one of the things I want to talk about first is, oh my god, what are human rights? So basically in terms of a definition, what we can say is that they are the basic rights and freedoms that every person is entitled to regardless of their race, gender, religion, nationality, or any other characteristic. So these rights are inherent to every individual and can't be taken away or waived. So I just want to comment a little bit that taking something away is different from waiving a right. So when a right is taken away, basically what that means is someone is preventing you from using that right, or someone has, I don't know, said you don't have this right anymore. It was someone else doing it. On the other hand, waiving, WAIVE, what that means is you yourself are giving up that right. So, for example, if something bad is happening and I'm just like, oh, okay, no, that's fine. Some people would say that you are waiving your right to complain about it later. If you're given a chance to fix something and then you don't take that chance, people would say that you waived your right to complain about that exact same thing. And at the same, or for example, if you consent to having something done and then you decided later on that you didn't like it, you're not allowed to do anything about it because you waived your right to complain. So when it comes to human rights, they cannot be taken away. They cannot be waived. So even if we're talking about like a government has the ability to restrict or regulate the use of a human right, for example, free speech, but that does not mean that they took away your right. So I am not allowed to Am I allowed to do hate speech in the Philippines? Okay, that's a weird example. Let's say libel or defamation. I am not allowed to make defamatory comments against anyone, especially if I know that it's false, right? So, in that sense, the government is limiting my ability to use my freedom of speech, but I still have freedom of speech. On the other hand, when we're talking about waiving a right, it's about did you do something about it or not? So, in terms of free speech, even if I spend 23 years, 25 years, my entire life without speaking, That does not mean I lost the right to free speech, right? So even if you don't do anything about it, even if you don't exercise those rights, you still have them. That's the whole point. And there are at least three characteristics of human rights. One is that they're inherent, they're part of the essential character of a thing, belonging by nature. Another is its universality. And lastly, it's that they're interrelated and indivisible. I'll talk about each one of these in a bit, but yeah, if you want to take a screenshot, there you go. There. So, first, let's talk about how human rights are inherent. What this means is that from the moment that they are born, humans are born, we have these rights. We cannot separate those rights from our essence or our existence as humans. So, when we say that something or some quality is inherent in any X, that means on a philosophical level that the thing, quality, whatever, is part of the definition of X. In the same way that having three sides is inherent in a triangle, right? We cannot separate the quality of having three sides from the thing that is the triangle. And in the same way, we cannot separate human rights from the thing that we call humanity, right? And this is for this reason, Jose Jokno said in a 1981 lecture that human rights are more than legal concepts. They're the essence of man. They are what make man human. It's why they're called human rights. Deny them and you deny man's humanity. And I just want to make a brief comment about gender neutral language because it is a product of its time, but I would prefer it's like humankind, but I guess like it's a stylistic choice, whatever, right? So, based on this, you can also say that human rights are inalienable. Because if they're alienated from a person, then indeed humanity too is alienated from that person. Moving on, second thing I want to say is that human rights are universal. That is to say, they apply equally to all people, everyone, everywhere, all at once. Everyone, every person is entitled to enjoy human rights without distinctions based on race, color, sex, gender, religion, etc. What this means is we all have the same rights. Like, I am not a Muslim, but someone who is a Muslim, we have the exact same rights because we're both human, right? And I want to quote at this juncture Karima Benon's 2018 manifesto about universality. She is the UN Special Rapporteur in the field of cultural rights, and what they wrote was universality is currently under sustained attack from many directions, including by those who misuse culture and cultural rights as a justification. Universality is not a weapon against cultural diversity, nor is diversity a weapon against universality. The two principles are mutually reinforcing and interlocking. In today's polarized world, we need a sophisticated multidirectional stance. You must simultaneously defend the universality of human rights from those seeking to use cultural claims as a weapon against rights, and at the same time, defend cultural rights and respect for cultural diversity in accordance with international standards when those principles come under attack. Basically, what this means is there are some people who say, let's not respect others' human rights because of culture. It's in our culture to disrespect another group of people, another ethnic group, or another religious group, for example. That cultural justification, having culture is also a human right. So, how do you judge? How do you weigh these two things? And according to the UN Special Rapporteur in cultural rights, what they said was that you cannot choose between one or the other because they're part of the same whole. And what this means is the best way to empower the right to culture is if everyone has access to that right to culture. And by extension, the right to everything else that is part of the human condition or what ought to be part of the human condition. They're interlocking. And it is this interlocking nature that leads me to the third, and in my view, the most important aspect of human rights, which is that they are interrelated and indivisible. If a person's right to a dignified life is not respected or protected, how could any of their other rights be respected or protected? Their right to work, right? If you don't fulfill the right to work, that directly feeds into your inability to do anything else. Why would you go out and use your freedom of speech? Why would you go out and vote? if you don't have enough money to buy food for the day, if you could not find work, if the state fails in its duty to give you an adequate standard of living or an adequate like working environment, all of your other rights will be affected. And on the converse, how could you demand for adequate standards of work if you could not use your freedom of speech to air out your grievances, right? And for this reason, there is no hierarchy between the rights that we have because they're all part of the same whole. That's according to UNICEF. So now I want to talk about the Philippine Blooming Mills case, which I think is a very interesting case that we talk about no hierarchy of rights. So in this case, the title is Philippine Blooming Mills Employees Organization versus Philippine Blooming Mills. Yung Philippine Blooming Mills Employees Organization, you can think of it as a union, right? May union. And so workers joined a strike against alleged abuses of the Pasig City Police Department. That was in the 1970s. And they were fired because their collective bargaining agreement had a provision entitled no strikes, no lockouts. So basically, what this means is since they participated in a strike, they violated the collective bargaining agreement, and that's why they were fired. Now, before you get mad and say to yourself, this is a bad provision in a collective bargaining agreement, how could there be no strikes? That would be like we were on Twitter, we would tweet something like that. Before you say that, consider the following. The first one is that the CBA, the collective bargaining agreement, was voluntarily entered into, meaning the employees did not have to agree to this provision, but they did. So I don't think it's proper that we undermine the agency of the employees, even if the result wasn't that good. But secondly, the provision does prohibit strikes where employees stop work to protest against unfair labor practices, but on balance, it also prohibits lockouts, which is when employers refuse to let workers enter the workplace and work. And this is important because without work, there could be no pay. So I don't think it was completely unfair to have this provision. In fact, I feel like it is designed so that people just keep working, right? There's no stopping of business, which would be good for the employer. And there's no stopping of the payment of salaries, which would be good for the worker as well. But lastly, I also think that the CBA also had probably some grievance mechanisms that would have made resolving differences between employee and employer possible without a strike. You can disagree with me on this. I understand if you do disagree with me on this because you might argue that, there's a power imbalance between the union and the employer, stuff like that. But whatever you feel about the provision, since they joined a strike against Pasig Police Department, they were found by the employer to have breached the CBA and were fired. So what did the Supreme Court say? The Supreme Court rejected the claim of the employer because the CBA provision only prohibited strikes where the employees were protesting against the employer, not against the government. And the reason for this is under the labor code, the definition of the word strike is to stop work through concerted action of employees as a result of an industrial or labor dispute. So if it's not a labor dispute, it would not be considered a strike. So if the justification for why you are stopping work is to protest against the government, that is not considered a violation of this particular provision. But going back to human rights, the Supreme Court did a kind of even if argument. Even if the CBA was violated, it was still more important that their constitutional right to petition the government for redress was respected and fulfilled, even if it might come at the cost of the right of the employer to have a steady revenue source. The court said that, and I'm quoting them verbatim, while the Bill of Rights also protects property rights, the primacy of human rights over property rights is recognized. Because these freedoms are delicate and vulnerable, as well as supremely precious in our society, and the threat of sanctions may deter their exercise almost as potently as the actual application of sanctions, they need breathing space to survive, permitting government regulation only with narrow specificity. Property and property rights can be lost through prescription, but human rights are imprescriptible. If human rights are extinguished by the passage of time, then the Bill of Rights is a useless attempt to limit the power of government and ceases to be an effective shield against the tyranny of officials, of majorities, of the influential and powerful, and of oligarchs, political, economic, or otherwise. So the difference basically between a property right and a human right, according to the court, is a property right, you can waive it, you can abandon it. So if I have a pen and I lose it right now and I don't care about it, I abandon my claim to it, in 30 years, when I see someone else holding that exact same pen, I don't have the right to say, hey, that's my pen, give it back to me, because I already gave up my right to have ownership over that pen. That's what they mean by prescription. But human rights are imprescriptible. That is to say, even if I don't use it, even if I don't assert it for 30 or more years, or even for 100 years, you still have that right. So in this case, the Supreme Court went against the principle. I think at first glance, the Supreme Court went against the principle of interdependence and indivisibility. Because if UNICEF is correct, that is that there is no hierarchy of rights under international human rights law, why did the Supreme Court say that some rights had primacy over other rights? Isn't the first human right in the Bill of Rights the one about life, liberty, and property? Wouldn't it have been better just to rule that there was no violation of the CBA and just keep it at that, rather than doing an even if argument that might diminish the consistency of principles? And just like this is me doing the devil's advocate thing, I think what the Supreme Court can say is there really is a difference between human rights and property rights. This is the traditional view. There really is a difference between human rights and property rights because generally, property rights are state given. They only exist if the state recognizes it. So while there is a human right to an adequate standard of living, which I foreshadowed earlier, that does not necessarily equate to a right to property. And the reason for that is you can have a good life, you can have a home without necessarily having to own the house or the land that you live on, right? You can have welfare, stuff like that. So, on one hand, you can only enjoy property because the state created a system of private property. But on the other hand, you were born with human rights like freedom of speech, freedom of religion. The state did not give you those rights. Rather, you gave the state the duty to protect that inherent right through something like the social contract. That being said, this position is still debatable because we have articles like this, The Global Right to Property by John Sprankling. They argue that there is such a right to property, that it is a human right. They said, let's explore the different sources of international law. There are four, right? I wanted to give another lecture about this, but maybe next time. So there are four sources of international law. One is treaty. Treaty is basically like agreements between states that they commit themselves to limiting their sovereignty a little bit in exchange for something else. The second is custom, which is basically state practice. If all states do the exact same thing, it would be a custom, right? It'll be just like a general practice that we have. The third source is a general principle of law, which is a principle that most civilized societies have as a basis for their laws. And lastly, secondary sources, such as like the opinions of the most qualified writers and scholars and stuff like that. So this article is trying to be the fourth one, like the article that changes people's minds. But this article also looks at the other three sources to derive the global right to property. So, first, they said that the near universal ratification of anti discrimination treaties arguably recognizes the right to property, and that might provide a basis for justifying the right under treaty law. Secondly, in terms of custom, number one, there should be actual state practice, which means that most states need to be actually doing this. And the second element of customary law is opinio juris, which is, I think, a Latin term, which basically means that The reason why they were doing this practice was because they believed that they were obligated to do. So, according to this article, they said that because you already have so many domestic laws across most states that recognize and protect the right to property, it should be viewed as a customary law. And lastly, when it comes to general principles of law, they said that because the domestic law of virtually every nation embraces the right to property, it should be recognized as a general principle of law, which has universal application. That being said, that's a lot. Matter dump ako sa inyo. But let's zoom out of that discussion about property. We can go back to the facts of our legal system. The fact is that whether property is a human right or not, in our current legal system, there is still a hierarchy between rights. At best, it is consistent with the idea that human rights are different from property rights. At worst, it's inconsistent with the idea of indivisibility and interdependence of human rights. Whatever side you're on in this legal debate, there are real implications that affect how people enjoy their rights and the ability of the government to restrain those rights. So, beyond the case of Philippine gluing mills, the Supreme Court has talked about the difference in treatment between fundamental rights like freedom of speech, freedom of religion, etc., and not so fundamental rights like property rights or the right to have contracts not be impaired by state action. So, in particular, we're talking about three levels of scrutiny. This is the analysis that courts will use to determine whether laws that restrain or limit those rights are valid and not unconstitutional. So, the first one is the rational basis test. Under the rational basis test, there should just be a valid state interest. Like, it doesn't need to be important. It's just, yeah, I guess it's fine for the state to want this. I guess this is a public purpose. So it just needs to be valid. That's one. And the second one is that the law, the limitation of the right, should just be rationally related, just related to the achievement of the interest. It doesn't need to be like, yeah, we're going to get the interest that we want by having this law. It just needs to be kind of related to it. So for property rights, this is the test that we use the most. And so the person who is challenging the law, siya dapat mag-approve nito. So if there's a law that restrains your right to property, you are the one who needs to prove that there is no valid state interest or that the law is not rationally related to the achievement of the interest. So as you can see, that's such a low bar for states to clear. And that's such a high bar for people who are challenging it to prove. So the deck is stacked against the right to property in general. The second level of scrutiny I want to talk about is intermediate scrutiny. That's the next level of judicial focus on challenged laws. In order to pass intermediate scrutiny, it just needs to serve an important, not just valid, but important, right? So it's not essential to the existence of the state. It's not life or death, but it's still very important. It's something that we'd like to have, something that would be nice to have, right? It's important. But secondly, it needs to be substantially related. So it's not enough for you to say here that it's not enough for the government to say that, oh, this is related. See, we use the same terms. It's the same people who are going to be affected. It needs to inch towards the completion of that. And where do you use this? So for rational basis test, we use that for, again, property rights. But for intermediate scrutiny, we don't use it. But the American Supreme Court used it in 1976 to determine the validity of a law that discriminates based on gender or sex. So if there is a distinction in the law that is dependent on your gender or your sex, probably the courts will use intermediate scrutiny. Yun nga lang, I think today we are all more leaning towards the idea that there is a right not to be discriminated on the basis of sex or gender, which means that is a fundamental right. And that leads me to strict scrutiny. This is the highest level of scrutiny applied to courts, to government actions, or laws. The US Supreme Court has determined that legislation or government actions that discriminate on the basis of race, national origin, religion, and alienage, meaning where your parents come from or whether you're foreign or not, it must pass this level of scrutiny to survive a challenge. If it doesn't pass that challenge, it is unconstitutional. One of the things that I want to mention in order to distinguish it between rational basis test and intermediate scrutiny is for rational basis test and intermediate scrutiny, the person who has the burden to show that it's invalid is the person doing the challenging. So if I'm going to challenge a law and it's not a fundamental right, I need to prove that there's no valid state interest, or I am the one who needs to prove that there's no important government objective. I'm the one who needs to prove that it's not rationally or substantially related to achieving the objectives. But for strict scrutiny, because this is a fundamental right we're talking about, we presume that it's unconstitutional. We presume that it's invalid because we're talking about human rights. You can only limit human rights if there are very special like considerations or circumstances that might warrant it. Specifically, the government is the one that needs to prove two things. First, that there is a compelling state interest. That is to say, it affects literally the lifeblood of the entire nation. So the reason why you have it is to protect a compelling state interest. And secondly, the state has the responsibility to prove that the law or regulation is narrowly tailored to achieve its result. That is to say, there is no less intrusive means of getting that result. So if you're taking a look at, let's say, mandatory vaccination, that's right to privacy. That is a fundamental right. Especially if like they're gonna jam something inside you. That is a that affects your right to privacy. That is a fundamental right. So there are situations where people argue that there shouldn't be mandatory vaccination because it's not narrowly tailored to achieve the result. Even if solving the pandemic is a compelling state interest, it's not narrowly tailored to achieve its result because there are less intrusive means of getting that result, like social distancing or enforcing social distancing or information drives, vaccination drives, etc. Right? Or incentivizing people to get vaccinated. So, ayun, those are the three levels of scrutiny. And you can use the rational basis test in a debate if it's about let's limit the right to property and someone says, oh, but having property is a fundamental right. You can say, no, actually, it's so easy to restrict rights to property. And I have so much precedent. I have so much matter on this. Or they can say that oh, it's okay for us to limit the free speech for the greater good. You can say, oh, no, you need to prove at least two things that there's a compelling state interest and that there is no less intrusive means to do that. I also have precedent for this. Ganyan. So that's how you can use this in a debate. But considering that a fundamental right for strict scrutiny is, it's sometimes debatable. Like in the United States, originalists and textualists, meaning to say they just read what's on the paper of the Constitution and think about what the framers were thinking, what the writers of the Constitution were thinking when they wrote that. They disagree with the idea that you can just say, this is a human right now because of more recent experience. So that's the difference between being an originalist and being a living document advocate for how we read and understand the Constitution. But what both of these groups of people will agree on is that there are fundamental rights. And these can be found in the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. So these three, at the very least, form the International Bill of Human Rights. Some people say that it's like up to 10, right? But the bare minimum that you need to know and the bare minimum that you need to read, the UDHR, ICPR, and ICESCR. But there are also other human rights treaties such as CEDAW, which is the Convention on the elimination of all forms of discrimination against women, or the CRC, which is the Convention on the Rights of the Child, etc., etc. But I recommend, if you're just a beginner, just read the UDHR, read the ICPR, read the IAC ESCR. There are books that you can find online that have commentaries for this. So if you get one of those books, what you will see is, oh, here's an article. An article is just a provision of law. It's not like a very long thing. Here's one article, and here is how we understand. Ganyan. You can just do that. And for sure, I'm 100% sure, like, you'll be glad that you did that to yourself, that you made the extra time to research. But now that we know where we can get those rights, just like the codification of those rights, I think it's time for us to talk about what are the components of a right. Because when we talk about rights, we talk about two components. The first is entitlement. If you hold a right, you are entitled to the use and recognition of that right. So, for example, if you have the right to free speech, that means you are entitled to the use of the right and you're entitled to others' recognition of that. The second component is duty. Having rights comes with certain duties and obligations, both for you as the holder of the right and for the government. So, for example, as the right holder, you have the duty never to abuse your rights to harm others or the general public. But at the same time, the government, as the primary duty bearer, they have the duty not to unfairly or unreasonably limit your ability to exercise your rights. The government also has the duty to make sure that you can actually exercise your rights. So, for example, the government can't just say that you have the freedom of speech, you have the right to protest and go on strike against a bad government official, but you have to do it somewhere where that government official will never see you. In that case, the government failed in its duty to make sure that you can actually exercise your rights in a meaningful way. And that is an actual case that happened in the United States because one of the states prohibited people from going on a strike or from holding a protest against a diplomat or representative of an oppressive country. Technically, they had the ability to do that, but they can only do it like X meters away from the place where that representative is at. So basically, it's saying that the state was saying that you have the right to protest, but just not anywhere that people who matter can see it. Yeah, so in that case, that is an unreasonable limitation of that. So one example of another example of a situation where a government unfairly limits a person's ability to exercise their rights is when the government imposes restrictions on, again, freedom of expression. If the law prohibits citizens from peacefully protesting or criticizing the government, just for sure, violation yan of their right to freedom of expression. Or if there's a law that prohibits you from having a certain belief, that is already a violation of a particular right. That is per se an unfair limitation. So to understand this further, I think we need to remember that even if the government has the right to regulate the use of or exercise of rights to protect the public good, the regulation should never be unreasonable or unfair. So if you argue that it's unreasonable because the law bans not just speech that could harm society, but also beneficial speech that points out where society could be better, you can say that it's unreasonable or unfair. But more than that, since we talked about one component is entitlement, another component is duty, let's dive into each one of those components. So when we're talking about entitlements, it's not just one thing. You have a bunch of core entitlements. Rights are a bundle of entitlements, truly. So to really enjoy the right to life, it's not enough for you to just be alive, right? The conditions of your life also have to be dignified. So for example, if we're talking about the right to food, this is another example. If we're talking about the right to food, it's not enough for you to just have something to eat. If that thing is extremely unhealthy for you to eat, yeah, the government is providing for us, fulfilling our right to food by giving us sticks of butter to eat. Ganyan. That's not fulfilling the right to food. The example I put here in the PowerPoint is pagbag. Pagbag is a piece of food half eaten or something, refuse that is usually found in the trash. And the reason why it's pagpag is because it literally means like brush off. You need to brush off the dirt on it before you eat it. So technically you are eating, but it's not necessarily a fulfillment of your right to food, which by the way is an actual human right that you can find in the Covenant on Economic, Social, and Cultural Rights. So there are fact sheets that are published by the UN Human Rights Council that gives the core entitlements to many different rights. So, for example, the right to adequate housing. It's not just you having a house or a place to stay, because what if it's just a cardboard box? What if it's dangerous to live in that place? What if anyone can kick you out at any moment? What if you don't have access to water? What if you need to pay an arm or a leg in order to get that house? I don't think that's adequate housing, and neither does the UN, which is why they made the fact sheet that you can also access for free. And you can also access fact sheets for a variety of other human rights that set out the core entitlements of rights. So, in the case of adequate housing, it's security of tenure, which means that you are protected against unreasonable evictions. It's availability of services, which means do you have access to water, sanitation, etc. Affordability, which means if you're paying rent or if you're paying for this land, is it so costly that it prevents your use of other rights? For example, the right to education or the right to work or the right to health. Habitability is also a big thing here. It's another core entitlement, which is it safe to live there? Is the roof going to collapse at any moment? Is there a landmine somewhere? Which is something that I'll talk about again later because in Marawi, right, there were unexploded ordnances or unexploded mines that were just there. So they had to, there was a proposal to move the people, like relocate the people who are affected while they're digging up the mines, put them back. Because if they don't do that, is a violation of the habitability aspect of core of the right to housing. Another one is accessibility. Accessibility is different from affordability. Affordability is can you pay for it? Accessibility is do marginalized and disadvantaged communities have the ability to get it? So there are some places kasi in the Philippines that say, oh, we were very interested in having you rent out the space here, but we found out that you're a Muslim. And because you're a Muslim, other people who are living in the area are not comfortable with that. So we're not going to let you sign the lease agreement. So that actually freaking happens. And that is a violation of the right to adequate housing. Location as well is a big thing. Like you could have a house, but it's at the top of the like up a mountain, and the nearest hospital, the nearest school is at the bottom of the mountain. Cultural adequacy. Does it prevent your participation in your own culture? So this is fact sheet number 21. There are other fact sheets. I have them open in other tabs if you want to see them after the lecture, but I'll move on for now, okay? Next, I want to talk about obligation, specifically the obligation of the state, because the state is the primary duty bearer. The reason for that is usually, in order to establish a human right, there needs to be a treaty. A treaty is an agreement between states. So, if a state agrees, oh, we will protect, respect, fulfill rights, sila yung magiging duty bearer, not any other person. So, if, for example, you say, this person is really violating my human rights, that is technically not true. Because in order to violate human rights, you must have a duty to respect it. But I think this is still debatable, right? But generally, like the very strict view is other private individuals don't owe you anything. They don't owe you space with which to say hateful stuff, right? They don't owe you a space on Twitter to shit post. It's primarily the state. And that's the reason why some originalists, some constitutionalists, Antonin Scalia, said that the Constitution doesn't say that you're not allowed to be racist. The Constitution allows people to be racist, he said. The only thing that the Constitution stops or prohibits is for the state to be racist. So as long as the state is not racist, you can be as racist as you want. That's basically what they're saying. But again, it's debatable because some people are saying that, okay, one of the ways to fulfill the duty of a state is to prevent other private people from being racist. Another medyo developing part pa is what is the role of a corporation in protecting human rights. Like they're not a states, they're technically not a treaty to human rights treaties, right? They're technically not a treaty, but states can still enter into agreements with them. For example, the Asian Development Bank is not it's not a state, but the Philippine government still entered into an agreement with the Asian Development Bank. And that's the reason why there was a case where one of the employees at the Asian Development Bank was being quite mean to a janitor. So the janitor sued, and the argument of the employee of the ADB said, "Oh, I have functional immunity. I'm immune from this suit because we were given that immunity from a lawsuit because of this agreement." And while the Supreme Court said there was, yeah, that's true. You do enjoy immunity from suit, but only if it relates to your official functions. If it doesn't relate to your official functions, no dice for you. So in that case, berating a janitor is not part of your duties to the ADB. So come on, you're right, but ultimately you're wrong. And ultimately you do need to be sued, right? So anyway, tangent. Anyway, the state has 3 to 5 duties, the core duties, depending on who's talking. Ako, personally, I think that there are 4. Other people just say 3. Other people say 5. So for me, the 4 that are most important are the duties to respect, protect, fulfill, and provide remedies in case of violations. Those 4 duties I feel like are the most important because respect means the duty to respect means that the state will not do anything that will hamper the enjoyment of the right. So I will not stop you. The state is saying, I will not stop you from using this right. Okay? It's a negative duty. I'm not going to do anything. But it's also a duty to protect. There's also a duty to protect, which means that I will also stop others from hampering the enjoyment of that right. So that is the positive aspect, one of the positive aspects. And finally, the third one, the classical one, which is the duty to fulfill. Let's create conditions that enable you to enjoy that right. The duty to provide a remedy is very important, but it's often overlooked. Because if someone violates that, or if the government violates that right, there needs to be a remedy. So usually when I read laws from a human rights perspective, I see, oh, okay, they're trying to respect the right, they're trying to protect the right, they're trying to fulfill the right. But sometimes there's no remedy whenever something bad happens. And I'll talk about an example of that later. But the last thing I want to talk about is the responsibility to recognize, to acknowledge that the right exists in principle. So itong duty to recognize, I feel like it's like already inherent in respecting, protecting, and fulfilling and providing remedies. I already feel like it's part of those things, but I do understand the position of other people where, look, there is still a duty to say that this is a fundamental right so that they cannot just remove these safeguards in the future. So in UP Diliman, this was a big deal almost a decade ago, actually. Almost a decade ago, there was a big issue about the Magna Carta of students' Magna Carta. And one of the reasons why it was opposed by one of the political parties was because there wasn't a comprehensive recognition of the right to free and accessible tuition or free education. And it didn't protect the rights enough because it didn't give enough of a remedy because if the rights are violated, pupunta rin siya sa Board of Regents who aren't always student friendly, stuff like that. So By using a human rights perspective, like using these frameworks, you can apply it to so many other policies, so many other statutes or whatever, right? So here's how you were taught to build our human rights analysis. So on one hand, we already know that there are core entitlements. On the other hand, we know that there are key duties that the state has. So when building your human rights analysis, you can turn it into a table where the y-axis is about like the core entitlements. Sorry, do you call it axes? Sorry, the first column is about core entitlements, and the first row is about the duties to respect, protect, fulfill, and remedy. So you create a table and just say, okay, core entitlement one is about accessibility of food. So the row that corresponds to that core entitlement, you can just say, oh, how does this law respect this entitlement? How does it protect this entitlement? How does it fulfill this entitlement? How does it provide remedy if this entitlement is not respected, protected, or fulfilled? And just do the same thing. So here's an example that we used for class. I already foreshadowed it, which is the Marawi siege victims compensation. And one of my classmates, I won't say who, talked about how it affects the right to housing. Hold on. I just drank some fluids. Yeah, so I wanna just in order to not make it super long, because honestly it was like 10 pages long. I just want to talk about three core entitlements. The security of tenure. That means you're not going to get kicked out or you have the right to remain there. The second core entitlement is affordability. And the third one is habitability, which isn't super dangerous. So for tenure, what my classmate said was yes, this Senate bill respects the entitlement of tenure because the displaced residents, if they're relocated, they may benefit from the Marawi Recovery, Rehabilitation, and Reconstruction Program's land titling program. So you were relocated so that the unexploded mines can be dug up, but later you can be a beneficiary of a titling program, which means that you would be given a title to that property. You would be the owner of that property. And because it's a government title or a Torrens title, this is a different field of law. But if it's a Torrens title kasi, no one can, generally speaking, no one can challenge that. Conversely, kung wala kasing title, if there's no title, there is no notice to the entire world that is your land. So there have been cases where someone was an occupant of untitled land and then they left for I think 30 years and then during that time someone else possessed that property for that period. And because the land wasn't titled, there was acquisitive prescription. Earlier, right, I said that property rights can be waived by prescription. That means you can abandon a property and someone else can get ownership of that just by possessing it for a very long time. So if you abandon an untitled land and someone else possesses it for 30 years, if you go back, you can't kick them out because it's no longer your land. But if it's covered by a torrents title, I think sabihin nun is you can stay away for 80 years and then when you come back, you'll find an entire family and then they have also been living there for 80 years and you can say, no, sorry, that's my land. Get out. Syempre, there are other complications there. I think under the Lina law, you need to find a place to relocate there or something. Said that, I wouldn't say that it's right for you to just kick out the family like on a moral view, right? I don't think it's nice to just kick out a family who's been staying in that place for 80 years just because you have a piece of paper. But anyway, that's part of respecting the right to tenure. Does it protect the entitlement to tenure? My classmate said no, because private properties get demolished in order to recover the unexploded mines. And even though that they provide for demolishing, it does not provide for returning or giving a compensation to the people whose houses were demolished or structures were demolished. In terms of fulfillment, my group mates also said no because their eviction may be permanent if they are unable to benefit from the land titling. And if they're evicted, no remedy was provided. And they just did this again and again for affordability and habitability as well. Affordability, no, because compensation for eviction is based on the fair market value and not the needs of the people. That's what they said. Sorry, that's what my classmates said. And I get their point because if there was a terrorist attack in the area, for sure the fair market value will plummet. So it's not commensurate with what you actually need, right? On the other hand, protecting affordability, there was no provision found about this, but fulfilling the conditions where you can enjoy the entitlement of affordability, they said at least, yeah, the government covers the cost of the compensation. But if it doesn't, if it fails to do that, no remedy was explicitly provided. And lastly, for habitability, obviously they're trying to protect something, protecting you from mines. That's it. And as you can tell, like I spent quite a long time discussing that. So just making this table, use your debate brain to make three structural reasons for why something respects this, something protects this, something fulfills this, etc. Okay. Next thing I want to talk about is the mental health law. So in the mental health law, obviously it's about the right to health. There is a right to health in the International Covenant of Economic, Social, and Cultural Rights. If you want more on this, check out General Comment 14 of the Committee of Economic, Social, and Cultural Rights. Kasi dito nila nilagay yung mga core entitlements. So one is availability, which means that there must be sufficient quantity of medicines. It's supposed to be accessible as well to minority or disadvantaged groups. It also needs to be acceptable to different cultures. Those are the three core entitlements that I picked out from their presentation. And they made a bunch of arguments for why some parts respect each of them or don't respect each of these entitlements, protect each entitlement or not protect each entitlement, fulfill, etc., etc. You can take a screenshot if you're watching this live or if you're watching this on YouTube or maybe on Facebook. You can take a screenshot right now and then build on it. I don't know. But lastly, I want to talk about an actual debate motion. I feel like this is why you're here, right? So, in pursuing food security, this House believes that developing countries should pursue protectionist policies rather than trade liberalization for its agricultural industries. Since it's about food security, it's about the right to food, which is why I was like, oh, I have a file on that. That's fact sheet 34, the right to adequate food. And so I know that in order to pursue food security, one of the things I need to talk about is it available? Do we have enough natural resources to have food security? And would it be available for sale in markets? Second, I can talk about the core entitlement of accessibility. And under the right to food, accessibility is economic accessibility and physical accessibility. And lastly, I can talk about adequacy, which is does it fulfill your dietary needs? This is fact sheet 34. By the way, this motion is from Magiting Cup. And I said, when I case built this in, I think that was 2021, when I case built this, immediately I was like, oh, we can talk about respect, protect, and fulfill. If we're talking about respecting the entitlement to availability, we can say that, oh, through tariffs, we can have a stable supply of food. We can have a sustainable supply by preserving rural livelihoods. So we're not as vulnerable to like global financial crisis or like a pandemic that disrupts supply chains in like international trade. You can also say that we're going to have reduced dependency on food imports. So during times of global crisis, we won't need to import so many onions, right? Like we protected enough of our onion farmers so that we don't have a shortage. Protecting availability, you can say that because you're protecting like local industries, that prevents a race to the bottom. Because if they have to compete with other countries, there is a race to the bottom in terms of price. And that would be good because in the long term, it's less environmentally degrading. The reason for that is if you have to compete with a foreign food importer, one of the things that you want to do is expand and take advantage of economies of scale. That is to say, let's destroy more forests to have bigger plots of land that we can cultivate for more corn or something like that. And that's the reason why places like Brazil shaved off a huge part of the Amazon forest, right? So in the long term, trade liberalization for agricultural industries might lead to race to the bottom economics, which leads to long term environmental degradation. You can also argue that it prevents exporters from price gouging during times of crisis. In terms of fulfilling, again, this is about how do we best create conditions that empower people to exercise the right. In this case, you can say that, oh, we can use this to improve rural agriculture, more subsidies in research, which will lead to more productivity, which in turn leads to more availability. You can also argue that it creates more targeted policies and programs to improve food access and distribution. And you can do the same process with the different core entitlements. And I think at this point, I want to end with a message about if you want to do this, if you really want to be an advocate, what you actually can do is use this framework and from this table, using your debate brain, right? Like structural reasons, do more research, etc., you can create like letter or a petition for for your local legislators or for even our national congress, right? You can do that. One of the things that we wanted to do with this was to actually turn it into a letter and send it to a member of Congress. I talked about the right to internet, which doesn't have a fact sheet because it's still a debatable right. So if it's a debatable right, what you can do is just create your own core entitlements and then argue based on that, which is what we did for the right to internet. And we used it to comment on Win Gatchalian's bill about having more like internet satellites and stuff. So, yeah, it's something that you can definitely use in your life, not just in terms of debate, but in terms of being an advocate as young as you are. Because I don't really believe that there's no prerequisite to be an advocate, right? Like, you don't need to have graduated from high school or even college or even law school because human rights are supposed to be there to protect you and to respect your enjoyment of rights and to create conditions that will make you happy, right? So I hope that you leave with at least that message that you have more power than you actually think you have right now. I just hope that with this sort of lecture, I gave you some sense of how you can actually use your debate brain to fight for changes that you want to see in the world. So that's it for my presentation. I want to give you all an opportunity to either comment or share something or maybe ask me questions if you have any. Okay, go ahead. Francis, go on mute.
I just want to ask a bit about the theory of comparative advantages when it comes to.
Sorry?
I just want to ask what did the opposition argue about the theory of comparative advantages in developing countries? How can the government argue back or like fight back with those arguments that you provided a while ago?
Comparative advantage. For people who don't know what this means, it's basically either that there are two different countries. One of them is better at making corn, the other is better at making guns or something. So, under the idea of comparative advantage, it would be better for each one to prioritize their specialization in order to maximize like the amount of goods that we have in the world so that when you have trade one wins. Of course, there will be losers, right? Like in country A, where they specialize in making corn, the gun manufacturers in country A will probably lose, and vice versa in country B. So the question that Francis asked me is really about if they talk about that, this idea that in a globalized world where everyone prioritizes their own comparative advantage or their specialization, everyone wins. I think here you have to rebut it by saying that one of the ways that you can justify protectionism is to say that you can't just treat losers or people who lose out in international trade as like something that you can ignore because these are actual people that we're talking about, right? Like, even if it's true that the country as a whole will win, we cannot ignore the needs of the individuals who are going to lose out. We still need to protect them. So I think that's like on a principled level, you can say that. Because that's basically what rights are. Rights are all about a principle. Like, even if the rest of society would be better off if there were absolutely no people who were talking about how, I don't know, a certain president is good or something. Like, even if the society would be better off had these people not been allowed to talk about that, we don't care because we believe in human rights. We believe that they have the right to say that even if it is completely disagreeable. In the same way, we believe that there is a right to have adequate and dignified standards and conditions of work, even if we lose out marginally in terms of international trade. Yeah, did I answer your question, Francis?
Oh yeah, thank you.
I think fundamentally, these are two different issues, right? So I think there might be a way to eventually say, oh, if we have protectionist policies, we can invest in research that will expand their productivity and make them more likely to compete and eliminate that comparative advantage in the first place. Maybe that's something that you can argue. But I think that realistically, in real world terms, right, it's really about pragmatics versus principles at the end of it, right? Like, outcome independent, it's about principle versus pragmatics. And I feel like in that case, you have to argue talaga that we can't just leave these guys behind just because it's convenient for us to do. But you can also argue it on their terms. Even if we're talking about pragmatics, here is how we can address. Okay. Any other questions? Yeah, go ahead.
I was wondering, I guess not so much as debate, pero in terms of passing laws that involve like human rights. So yung parang example po yung RH bill. Like, how are you able to like convince people na parang women's autonomy is important, especially with the framework of seeing things differently, so, like being the life majority of the time here?
Sorry, could you repeat that?
Oh, how do you in debate like in actual in a like, court? How is it like us po try to advocate for something like yung women's autonomy here in the Philippines?
Did you say in
How do you
court?
manifest that while considering, yeah, like how do you parang argue po, considering the optics where people are more pro-life? That
That is the work that we need to do. That's actually part of the work that we need to do. We need to communicate to them that when we're talking about human rights, we're not trying to take away from you anything. We're not trying to justify that drug users should come in and kill your friends and family and ruin people's lives. Like, when we're talking about bodily autonomy, we're not saying let's take away your freedom of religion. We need to do more work in trying to convince people that just as we have the RH bill doesn't mean that your right to have a religion is going to be taken away. Just because we have gay marriage or just as we have the Soji bill, it doesn't mean that your freedom of religion will be diminished. Sure, what will happen is, like, you might feel offended, but we cannot base our entire system of laws based on your idea of offenses, especially if the other hand is not respecting people's human rights. So we do need to put in the work here to, and one of the things I want to emphasize is we shouldn't be overly antagonistic. The way that I packaged that was antagonist. So when you're actually talking to a person, it's better to like about let them talk about their own frustrations, their own insecurities about this, what exactly are they fearing? Right? Are they fearing that they're next? Are they fearing that they will go to hell if they don't speak out against the RH bill and stuff like that? Do they really believe that they can apply their religion to everyone else? Why do they think that? So I suppose that there is a therapy ish approach to it that really works, where if you come from a place of understanding, if you really try to understand them and then address their specific emotional concerns, I think you're more likely to turn them around on it. Perhaps you could say, okay, what if a Muslim tells you that you have to live by their religion? How would you feel about that? So maybe you can, from a place of understanding and empathy, ask them questions that reveal where they're really at, why they're really believing this. Yeah. So I hope that I answered your question. Luckily, that's super difficult because you need to have a better understanding of how people think, how people feel. And there is a huge amount of emotional labor for that. And some people are so tired of this emotional labor, which is why they lash out in places like Twitter. But ultimately, while there is a place and what they're feeling is valid, I feel like if you're actually talking to a person one on one, that is where you need to allocate a lot of your EQ, right? Yeah. So it is an uphill battle, but like I don't think that it's something that you can't win as long as you go from a place of empathy. And that's one of the things I want to say. Earlier you mentioned what about courts? The reason why I wanted to emphasize convincing people one on one first is because the courts are limited. They cannot do anything unless there's a law. The only thing that they can do is interpret laws, right? They cannot create laws. So the real battle is if there is no law that says there should be divorce, the Supreme Court, not even the Supreme Court can say there should be divorce, right? It falls onto Congress. It falls onto local legislatures. It falls on people like us, right? Advocates. I hope that I answered your question. Do you have any follow-ups before I move on to the next question? Chloe?
Follow-ups. Thank you.
No follow-ups. Okay. So someone said, is there a line between the values upheld by the Constitution and the values inculcated by religion? This is interesting, right? Because one of the places where we originally got our human rights was actually religion. Because I wanted to talk about this in the next lecture where I'm going to talk about like the philosophical basis for human rights. But I guess to foreshadow it, there is a line, but we still owe a lot to religion. The reason for that is one of the reasons why we had this idea that there are some rights that are inherent to the human condition is because we were created, allegedly created by a God that gave us the ability to say that, oh, I think that we deserve something more. We deserve a dignified standard of living. And because you were gifted with that sense of rationality, it's part of natural law to have this entitlement. Because if you achieve that entitlement, it is just basically us fulfilling God's plan. So before modern secular constitutions, we actually owed a lot to religion in the development of human rights. But now there is a line, right? Like you should have the right to religion, you have the freedom of religion, but you should not be able to actively victimize another person because of this, right? So in the same way, Sharia law, and this is the next question you asked, is Sharia law inclusive or divisive? If human rights is all encompassing, what I would say is it depends on the way that we implement the law, right? So I think, first of all, if I'm not mistaken, Sharia law, one of its principles is follow the law of the place that you're in. But even if there is a difference, what happens in our society, in our country is in order to protect freedom of religion, we need to make exceptions in order to accommodate them. So if people opt into Sharia law, they should be protected. But they cannot use Sharia law and impose it on a non Muslim, for example. And this also implies that there is a duty to protect people if ever they want to opt out of Sharia law. For example, if they opt in and they eventually find out, oh, this is not for me, freedom of religion should also mean that you have the right to switch religion. And the state should likewise protect that. So if you want to really protect freedom of religion, protect people who want to opt out of religion. So yun. I hope that I answered your questions. Are there any more? Okay, if there are none, thank you so much for attending this super short notice lecture. Actually, earlier I was trying to record it, but I lost internet. So I had to do it from the very beginning and I was so frustrated, which is why I was like, to make this interesting, how about I have an audience? So I'm very happy that you all decided to come and yeah, everyone else should be jealous because now there's class participation, FOMO and stuff. So anyway, that's it for this episode, lecture, however you're consuming this. I'll see you in the next one. Bye bye.